The 5 minutes of break has now ended. Next, Ms. Dr. Helena Wong, 2 minutes for a third round. I have a question for the police. The representative from the Cybercrime and Security Bureau. There's the offense of insulting behavior. If you openly and intentionally, publicly and intentionally play the national or insult the national anthem in any way is an offense, and this also regulate the online environment and online platforms. I want to know the scope of police gathering by the police. If some netizen notices that there's something insulting, video, image, or clips on the internet, and they share or show like in their groups, Telegram, WeChat, WhatsApp, or Facebook, if they show their like or give a thumbs up as an emoji, etc., to such material, was such act covered by your law enforcement? So how big is the scope? The producer of the material and the sharing, the sharer, and then a bystander who shows interest in seeing such material, and if that person claps his hand or say he likes it, would that also be part of, regarded as insulting behavior? And secondly, do you need to increase your manpower after this bill is enacted so that you can do cyber surveillance? This question has been asked and answered, but perhaps Mr. Chan, Chief Superintendent, you can respond in a brief manner. It depends on the circumstances of the case and evidence that we can gather. We will investigate every case thoroughly. At this stage, we cannot say how big the scope of investigation will be. Much will depend on the circumstances of the case, and we will collect evidence from all sides. But that's very abstract. Perhaps you can press the button for again, Dr. Cheng Chong Tai. Well, I had to attend a hearing of 2 hours. So sorry for not having to join you earlier. There's a question of distortion. Last time, the government said that it depends on whether the national anthem is played in a distorted way. And also you have to look at the posture of the player or the listener. Can you elaborate on what you mean by distortion? German 71B is about playing and singing the national anthem in a distorted or respectful way. This is really about the playing and singing of the national anthem. So we will look at the manner of praying and singing. Sorry, that's why I have this question. If you are talking about praying and saying in a distorted way, you are talking about the outward experience or the manner of expression. You use a squeaky voice and you kneel down while you sing the national anthem or whatever. I understand the English term, distorted. So what distortion are you talking about? Can you provide a model explanation? Or does it boil down to whether you have the intention to insult the national anthem? I understand the English term, the distortion, but why cook or distortion in Chinese is not easy to understand. Of course, you have to have the intention. You have the intention to insult the national anthem before you commit an offense under 7(1). And when it's talk about in a distorted or in a distorted way, you change the established way of playing and saying the national anthem. I know that some members have asked this. In the case of the U.S., some people knelt down while the national anthem was being played and sung. Would that be caught by 7(1)(b) in case of our national anthem? You have to establish that there's an intent to insult the national anthem. So the question is, with clause 7, is that you leave everything to the court. Before the case proceeds to the court, we have to gather evidence. We have to make sure that we have sufficient evidence before we really initiate prosecution. Dr. Fernando Zhang, I've heard that from Mr. Kwok Wai-keung that the insult is easy, is clear. But my last question was not really answered by the administration. I gave you an example. While the U.S. anthem was played before a game of football, American football, someone knelt down. There was no act of disrespect. The player, one of the players, knelt on one side. You may say that under clause 8 is a disrespectful, or if you talk about clause 3, you may say it's not in. Is this in keeping with his dignity? But we look at clause 8 and clause 7, where it's in publicly. Is this way? Is the act insulting or disrespectful? Or the intention? Are you talking about the intention to insult or to distort the national anthem? The intention has to be proved independently of A and B. Well, is the act I was talking about an act of insult or disrespect? Or is it against clause 7, which is for guidance only? Or is an offense under clause 7? In the example, of the act does not conform with clause 4, obviously. But under clause 7, you cannot say the act is in itself a proof of the intention to insult the national anthem. Mr. Kelvin Young, the offense of insulting the national anthem in clause 7, would that extend to aiding and abetting type of behavior? I think it's a Section 101 or Section 109 of the Criminal Procedure Ordinance. Maybe you can make some preparation, and I'll invite the Permanent Secretary to speak first. Well, incitement is an offense, because this is a criminal offense. It's a Section 89, a secondary offense. It's in our statute book already. Would the Bureau further elaborate? Under normal criminal law, aiding and abetting is a criminal law concept, and the incitement is another concept, as mentioned by the Permanent Secretary. Can you tell us the difference between the two sets of concepts? Well, incitement is an inchoate offense. It's incomplete. The real offense is not complete. Aiding and abetting is about completed offenses. One is an inchoate offense, the other is an offense of attempt. In terms of penalty, in respect of the two types of act on the part of a third party, aiding and abetting or vis-a-vis incitement, would the penalties be in line with what's provided for Clause 7, maximum penalty 3 years imprisonment? Incitement, if we look at 101I2, Section 101I2 of Criminal Procedure Ordinance, aiding and abetting is covered by 101. I can't remember the subsections. I think the public will know more about the issues covered by my questions. Maybe the law draftsman can tell us more in writing. Please provide written response. And secondary offense, we attract the same penalties as the substantive offenses, normally speaking. Ms. Claudia Mo, 2 minutes. Don't say I am repeating previous questions. I just want to clarify this. You don't have to apply, and you can use the national anthem for some commercial purposes in that you can print the score or the name of the national anthem on commodities, including the underwear. Am I right in saying this? Permanent Secretary, if there's no intent to insult the national anthem, the Act will not be regulated by this ordinance. So that will cover underwear, because underwear is not shown to the public by the wearer. But the manufacturer of the commodity will not be held liable. Is my understanding correct? I think he has answered you. That's a very reassuring.
你話篡改咧，就係包括咗一種奪取嘅。
And you talk about the alteration as taking over of something established. But has this term alter or alteration been found in other laws? I think we don't have this Chinese terms, 篡改 or alteration, in other laws. Chairman, no. Unlike what you are trying to suggest, Mr. Chen Jishin helped me. He has searched this on my behalf. I have to ask this question. Why is the Chinese term 篡改 rendered in English as alter? Because there's no taking over meant by alter. Why don't you use words such as tamper with or desecrate, which carry a deeper meaning and that has the connotation of taking over something or change. You talk about alteration, you are changing something which has already been established. The English version in the mainland is also the alteration. Well, English use in the mainland is not precise. You should do better in the English context, in the context of national anthem. I think if we are talking about something established, this is the right term. Have you considered using a desecration or desecrate? Because it's a usurpation. If you use 篡改 in the case of a change of regime. Mr. Ngao Lok Him.
I'd like to follow up on Ms. Mo's question. Since the word 篡改 in Chinese has not appeared in our other ordinances, won't you use terms commonly used in our local legislation. I think we're talking about the adaptation of the basic law. I think we've actually made reference of the national anthem law. So we need to reflect the intention of the national anthem law, and that's why we've tried to use terms as, close that would be the same as in the national anthem law. Now, there are different forms of drafting, which actually are the styles adopted in the mainland, and they're not the drafting style common in Hong Kong. Now you're now actually copying the national anthem law, and that's why we have this controversy. Secretary, I think this is an old issue. Now, Secretary, if I may add one more point. When are you going to adopt the mainland drafting approach, and when are you going to adopt the local drafting approach? I think you can never give us a satisfactory answer, Chairman. I've said many times already. Well, that's why we are adopting local legislation while making reference of the intention of the national anthem law, taking into consideration of local circumstances. So in some cases we adopt the national anthem law. Sometimes we would take into consideration our local system and local circumstances. Let me finish, if I may. Each and every time we would explain to members why we adopted such a drafting approach. If members have a different view, we will listen, but we explain why we've adopted the approach we have adopted. You said that you use the term 篡改 in Chinese because you need to actually tally with the intention of the national anthem law. So under what circumstances would you adopt a local drafting approach? Mr. Pang? Are there any local examples where there's no way you can do away with the word 篡改 in Chinese? Dr. Chen Cho-tak, I'd like to ask a question regarding the time limit in respect of 7A. According to the Magistracy Ordinance, normally we would look at the offence, which would attract imprisonment of 6 months. So I'd like the government to explain this clearly. They shouldn't just tell us that the time limit should be 2 years, after the commitment of the offence. 718, that is 1 year after the commissioner is aware of the commission of the offence. So the commissioner can say, I've just, learned about this. Which one are you referring to? Subsection 7A-B. Subsection 7A and B. A, of course, it's about the end of the period 1 year after the date on which the commissioner discovered the offence, and B, the end of a period of 2 years after the date on which the offence is committed. Looking at the two together, subsection 7, it's whatever the earlier. So when if it is 2 years after before the commissioner comes to the notice of the offence, then there would not be any prosecution. So my question is that the police commissioner can always say he just discovered that the offence has been committed. Sorry, I don't think that's clear. So he says so long as within 2 years. As to when the commissioner, discovered the offence, of course he may not know, but then we are also striking a balance here, and that's why in B we are saying the end of 2 years after the date on which the offence is committed, and the earlier of the two would apply. So we've struck a balance here so that we can ensure there's a reasonable time limit for prosecution. Hui Chi-fung. I'd like to go back to 7(2), that is insulting the national anthem in any way. Said that if somebody admits that he has publicly intends to insult the national anthem, but what sort of behavior will constitute an insult? Now, please answer the question clearly so that we know what is your intent. So what actually would constitute an insulting act? Are there any objective criteria to judge? Or is it that if the government said you have committed this act, and then it would automatically be considered to be an insult. So how do you, is there an objective or subjective determination of what is an insult? I think we've answered the same question at the last meeting, and we also provided a written answer to Tanya Chan's question. Understanding that if the court believes that it cannot be, we cannot accurately predict the possible methods of the committing of the offense, so it would be best that we will list the nature of the offense and then leave it to the court to judge, and the court will adopt a reasonable approach. So in other words, it is objective and reasonable, except that you're saying that it will be dealt with by the court. Yes, that has always been the practice under the common law system in Hong Kong. I think in your written reply to my question, you said that in any way, there are not many statutes or ordinances where the drafting was used a phrase like this. In many other ordinances, you talk about threat to life and property and so on. But I don't think we have other legislation which said in any way. When I said in any way, I was not talking about insulting in any way. So if Mr. Hui would like such information, we can download it for him very easily. So in any way that would, I think it's a question of fairness. Insult in other criminal, laws. So, criminal offenses in any way. Why don't you give me a list of such examples? Mr. Ray Chen, 1 minute. Chairman, I think you really have to help me and don't let the government evade my question. Otherwise, I wouldn't be able to make any headway. I said that if you breach the national anthem law, Yang Hoi Ling case where the person he was detained for 5 years, if the same act were committed in Hong Kong, would that be an offence and so on? The Secretary has not really answered the question. He said that you can't make a judgment based on that video clip. You may need to arrest that person and interrogate the person before you know. But in the mainland, of course, if you don't admit you're guilty, you'll be detained for a long time. If you admit, then you'll be detained for 5 days. Now, what's going to happen if this takes place in Hong Kong? The Foreign Secretary said you don't need to, find the person. I think the intention to commit the offense in this context is not like, sexual offenses or the infringement of rights that we're talking about. So is it that you have to wait until the court has made a judgment before you make the removal and so on? I don't think you've answered the question. Well, I think that question has already been answered. If the act itself, we believe it's a possible insult of the national anthem, of course, you ask the supplier to remove it. It's whether we would arrest that person, and after we arrest the person, and it's something else, whether we would determine whether he's breached the law. Well, I think in that case we should discuss the Yang Hoi Ling case. I think it's difficult. Well, this is a case law. I think judging from that video clip, you cannot judge whether or not he was committing the act deliberately. Helena Wong, I asked the question, that is, somebody share likes on the internet, would that be a breach of Clause 7? To breach Clause 7, the person would need to have, a specific and overt behavior and the intent. So it would depend on whether or not he has the intent. I don't know how you're going to enforce the law, because many people may see that video clip on the internet and they really sympathize with that and they share it and give the likes. And when people do that, they may not do that with any particular purpose. They just find it interesting and share it. So what are you going to do when you take enforcement action for all the people who have given likes to that video clip? Are you going to arrest each and every one of them and then ask these people whether they were sober when they gave their likes and whether they have the intention to insult. How are you going to enforce this clause? I think there is a threshold for the offence under Section 7. When we're going to prosecute, we have to prove that there is the intention to insult the national and there is the act. We will not automatically say somebody has actually breached this particular, section. You've not even seen that person. How do you know what his intention is just because he's given his like? I think you need to press the button and wait for your next turn. Gary Fan, 1 minute. We're talking about the offence of insulting the national anthem law, which is Section 7. The majority of the offences would be in respect of the audience or the public who is present when the national anthem is being played. And any insulting act would be an offence. But as to the organizer of the event when the national anthem is being played, I don't think you have many regulations in respect of that. Section 6 Scorsese only stipulate what are the occasions where the national anthem cannot be used. On occasions which is not official occasions, like an athletic meet, the jockey club, and so on, there are no guidelines as to what the organizer should do when the national anthem is being played. Regarding the playing for organizations playing the national anthem, Chairman, carry on. Now, giving the notice that the national anthem is going to be played at the scene, and for people who are present on the occasion, who will be present at the occasion, would need to, so that they can be prepared, so that they won't, they won't, be caught by Section 7. Section 7 refers to any person. Now, the organizer of the event would also be included. I think to commit the offence, you must have the intention to insult the national. If you don't have the intent, then you wouldn't be in breach. Next. Well, I haven't yet have an answer as to what would actually be compatible with the intent of the national anthem law. I did ask a question regarding the word alter in English. I said that the term 篡改 has not appeared in other pieces of legislation. So are you going to show, in other words, my question is the Chinese or English version, which one should be the authority? In 中文, in Chinese is 改動 for alter. The English translation is alter. For example, deletion and addition include erase, cancel, and add to. The word alter has a different meaning in these. Have different meanings in these two pieces, ordinances. The other one is the construction ordinance. The main difference between the two is that the bill is actually based on the national anthem law. So do you follow the Chinese version or the English version? I think the law draftsman has already explained that. Mr. Au, my understanding of what he means is that the construction ordinance, has technical considerations as to which terms should be used. But we do not have a national construction ordinance being applied in Hong Kong. What we have included under Schedule 3 is that we need to implement the national anthem law, and therefore we don't have a totally free hand when we draft the legislation. Let me further follow up, if I may. Looking at the English version of the national anthem law, the meaning of alter and the meaning of alter under the construction ordinance are not the same. at least under the national anthem law, the interpretation of the term alter is different from that as in the case of the construction ordinance. Would that give rise to any legal dispute? I think the context of the two ordinances are not the same. Under the national anthem law, we're talking about a national anthem law which already exists, and therefore using the word alter is appropriate. Dr. Cheng Chung Tai. I'd like to follow up on 7B. I understand that the earlier of the two should apply, so that the police commissioner can adopt, can prosecute, taking the longer period. Now, the offense, let's say if the offense is that somebody commits an act on the internet, I think there might be a gray area here. I think you can say claim whatever date you say the act was committed. Let's say that somebody alters the national anthem and sings the anthem, and the publication. I think if published on the internet, he will be actually breaking the law every day. I understand. I'd like to ask the commissioner whether he would like to respond. I think Dr. Cheng. I think what Mr. Cheng has a misunderstanding here. When we investigate any internet crime, we will conduct cyber forensic investigation to find out when the offense was committed. So I don't think we need to worry. Helen Wong, I'd like to follow up on the word publish in the context of Section 8, Clause 8. If somebody publish something amongst their own, WhatsApp group, for example, is it that this would not be a breach? Mr. Pang. Publishing to the public, if the public is not, doesn't mean it's not the whole world, but rather it's only published among members of a particular group, would that constitute publishing to the public? Is there a limit on the size of the group? That would depend on the meaning of public. We've conducted some research, and we will look at different case laws and the facts of those cases as to whether public actually constitute public. Of course, it would depend on the number and also the context. The context we were looking at whether or not public would mean 2 or 3 persons. Of course, that would not be. What about 30 or 50 people? Well, that would depend on the context. So we're not able to answer the question. I don't intend to publish it for the whole world. I just want to share it with members of my group. And you can't say what is the number that would define the group. So the public would not know. Mr. Fang, actually the word public would depend on the context as to how it is defined and how large a scope it should cover. Fernando Zhang, if somebody, let's say, publish something on Facebook, he makes a comment on the Facebook and he quotes the lyrics of the national anthem law, stand up those who don't want to be slaves. He said this is a lie because the Communist Party is actually treating people like slaves. So that could be undermining the national anthem as a symbol of the country. It's also undermining its dignity. And if somebody were to share this on the internet, after he has, of course, if he shared that, he would have published it. And after he has shared this, and other people would, add a clapping hand symbol or say, well said, and that is being shared, so the number of people involved would be quite large. Now, for these examples, would they all be considered to be in breach of Section 7?
Yes, this question has been answered many times. First of all, whether the materials that's published would lead people to think that is the national anthem. That is one of the elements. So if it's not regarded as national anthem, it's different. And if other people are sharing the material, we will have to look at the intent. That is when he shares the material, does he have the intent to insult the national anthem? Please turn on Mr. Al-Nokhin's microphone. Chairman, I'm long-winded. I am talking about the word author again. I'm not a legal professional. I know that when it comes to the law, we have to look at the context, and sometimes they have to interpret a term in legal ways. Now, I have found another piece of legislation that contains the word author, that is CAP 181. They use the word author in this piece of legislation. So what is the definition of author? Now, if there are so many pieces of legislation that contain the word author, but this time around you use a new Chinese translation of the word author, so what should the lawyer look at? The lawyer would have to look at the context, right? But now, with the same English words, you have different Chinese translations. So what should a lawyer do? Okay, so for the word 全改 in the marriage ordinance, what do you think? Well, for each piece of legislation, it has its own background and context. Now, for this piece of legislation, we are adapting the national law or national anthem law. So for the Chinese term 篡改, we think that it appropriately reflects the English word author's meaning. Mr. Gary Fan. Well, I'm mainly talking about the organizer of events. So how are you regulating the organizers? In terms of legislation, would you also regulate the organizers of such events in which the national anthem is played? Well, for Clause 7, it actually covers any person. As to whether the national anthem is respected is supposed to be a guideline. This is what I want to ask. Now, if the national anthem is played suddenly and the attendants or the participants do not know that the national anthem will be played, then they will be caught by surprise, and then they will be inadvertently caught. So I think you should announce in advance that the national anthem will be played, then I may choose not to attend that particular session of the event. So if you go to an event and if the national anthem is played, I think you won't just drop by such events. And if you are to be caught by this provision, you must have the intent to insult the national anthem. I don't think you would do that inadvertently. I also have the same concern. Just now, Mr. Hui Chi-feng asked about intent, and he cited Kong Siu case. Well, it is cited in that case that the national anthem would have to be protected in all ways. Now, because you have to prevent people from insulting the anthem in any way, but if that person eventually didn't do anything, then he might still be caught by 7.2 or 7.4. Now, if he has the intent, but there's no behavior, so would he be caught? So if he has the intent, but he doesn't do anything, then not all the three elements will be satisfied, so he won't be caught. I want to ask about the law enforcement under Clause 7. Well, the police have a cybersecurity and technology crime bureau. What's your establishment? How many people do you have in this bureau? Mr. Zhou Chen. Now we have 229 people. Are they all responsible for cybercrime investigation? Well, that includes our clerical officers, and we are all responsible for cybersecurity. So would you have to increase your manpower after the passage of this bill? If so, how many more officers do you need? At present, we do not think there is a need to increase our manpower. So now you have a lot of free time. So in the future, you can patrol online to prevent any crime against the national anthem. Well, we are responsible for investigating online crimes, but other police officers are also responsible. Our frontline officers, CID, and our headquarters teams are also involved in the investigation of cyber crimes. I would like to ask a question about a scenario when the national anthem is being played at an event, and in the course of playing that, if any person doesn't stand solemnly, and if he's not behaving in a way that is respectful, or he's pointing his thumb downwards, and if this is being taped by video or being reported, then the medium that has recorded such a scene then play the video, would he be caught by the provision? So what if he televised it? Well, so you are saying that there is a reporter and he's reporting on such a scene, then he's protected by 7(5) and he's not liable. Mr. Wu Chi, why? 1 minute. Thank you, Chairman. I want to ask about 7(7). The time limit for legal proceedings. So at a certain moment, a person reports it to the police. Then the police will start investigating. Or if you want to report it to the police, you need some prima facie evidence, and then investigation will start. So after you report it to the police, who decides whether the case would be taken up? So how about the expiry time under A and B? Well, from the time the offense was committed, if we count 2 years, then that would be regarded as the expiry date. But how about the investigation period? What kind of concept will you adopt? When will the police law enforcement procedure start? Are you talking about the word discover? Now, for discover, it means that the relevant person gets to know the relevant information to an extent that he knows such a case has happened. We have looked up the relevant information concerning the word discover. So it's not just about reporting to the police. Mr. Fernando Cheung? I'm not too familiar with this, so I want to ask this question. In Hong Kong laws, do we have the crime of insult? Other than defamation, do we have an offense which is called insult? Well, for Hong Kong statute laws, over 30 pieces of legislation covers the offense of insult. Now, if you go to the DOJ website, you can find this, and also at the LATCO website, you can also find the word insult. So, for the offense of insult, can the objective reality becomes a defense. Now, for defamation, if what that person says is a fact, then that can be a defense. So, can this be applied in this bill? Well, for this bill, we do not have this reasonable defense. So I think it's very subjective. So for the definition of insult, you say that you undermine the dignity of the national anthem as a symbol and sign of the People's Republic of China. But this is a very subjective interpretation. So when you define the word insult, if it's an offense, then you must give it a very clear definition, and you should provide a reasonable defense. Mr. Chifeng, for Clause 7, offense of insulting behavior, you have taken reference from Article 15 of the National Anthem law. But, well, for the public, it means public occasions. In Hong Kong, you just use the word publicly, so there are differences. So for the PRC version, it's about a public occasion. We're talking about physical occasions. We're not talking about the cyber world. But for the Hong Kong version, you use the words publicly and intentionally. Then you have broadened the scope to include the cyber world. Is my understanding correct, Mr. Pang? Now, for Article 13, it mentions public occasions. So it's to regulate public behaviors. It also covers online behaviors. So Clause 7 fully reflects Article 15. Have you consulted the legal professionals on the mainland? Article 15 really does cover the cyber world? We have made reference to the scrutiny meetings, and they say that this would include the cyber world. I would like to ask about subclause 7A. You use the words is discovered by or comes to a notice of the Commissioner of Police, and the draftsman says that there is an element of material facts. Can you tell me in greater details what is this concept of material facts? Now, reporting it to the police is a concept, but does that include the elements of material facts? Law draftsman, can I explain in English? Because the study is in English. So what is discovered?
Knowledge of the relevant and material facts that found the essential elements of the offense, including the identity of the offender, even if investigation are still required to obtain evidence of those facts in an admissible form. 個意思即係話，如果有個人佢有個
That means that is a person, he has the knowledge of the relevant facts, and those can become the foundation of proving an offense, something like that. So does it include reporting it to the police? Yes, but that also covers other scenarios. So I hope that he can give me more details. Well, he's just told you. Well, for that English passage that you just read out, can you translate it into Chinese and then give it to our secretariat? Mr. or Ms. Claudimo? Thank you, Chairman. I want to ask questions about some words. For lyrics, well, sometimes the English is lyrics and sometimes the English is words, and there's no difference between the two, right? Law draftsman? Well, for lyrics, well, throughout the whole bill, lyrics is translated into Gauzy, but somewhere you have used words. Is Ms. Mo referring to 8B? It's about some words and when they can become the lyrics. Hold on. And how about the word intent? Well, the Chinese meaning is 企圖, but if you have the intent, you just intend to do something, it may not become the reality. However, well, I'm asking a question about 7.1, but you translated word intent into 故意, that is deliberate, that is he has done that already, and afterwards you think that he did it deliberately, but is there a discrepancy here? Well, for English, 企圖 is attempt. Chairman, I'm talking about 7.1a. In Chinese, it says 任何人如而公開及故意. And here it says with intent to insult. Is there a contradiction or am I thinking too much? 意圖 with intent to insult. 故意 is intentional. That is about intentional is about the act of publishing, and the intent is to. So there is a difference between intent and intentionally, right? So now I understand. Thank you. Mr. Ray Chen, now if a person, if he's overseas and he insults the national anthem, then of course he has not committed an offense under the national anthem ordinance of Hong Kong. But if he's shot a film and put it online, then he's actually publishing it to the whole world. Then the person who shoots it may have committed an offense under bracket 3, but if that person shoots that video because he wants to expose this person's offense, what would happen? And then would that video be removed? Secretary. Now, if the law enforcement agency discovers suspicious crimes online, the police would ask the service supplier to remove the relevant materials. But if this happens overseas, then we cannot have control over that. Mr. Wen Siu-kin. Chairman, for Clause 7, yesterday I watched a video and that worries me. Well, on the 1st of May, Jackie Chan, Fok Wei Kong, and Kwang Mei-wen shot a video about the proper ways of playing and singing the national anthem. I have been worrying about this. Well, for your drafting, sometimes it's too subjective. Of course, the government doesn't agree. For example, 5.3. For example, subclause 3, insulting the national anthem in any way. Well, that that old lady stands up miraculously like Jesus. Well, I don't know what intent they had. Well, now she can actually sit up in her coffin. So what would happen? Would that be an insult? Now, if it's created by a religious organization, can they do that? This is very dangerous. Well, for our organization that is supporting the democratization in China, we also had this worry. If we shoot a video on patriotism and if we include the scenes of June 4th, would that constitute an insult to the national anthem? Are you talking about 7275? 75C? Well, we really have to find out whether he has the intent to insult the national anthem. If you talked about the video, when I answer Fernando Cheung's question, I already said that.
Is in respect of cross 4, it's just for guidance, etiquette for praying, singing. If you cannot stand physically, there's no problem. And if you look at cross 7, you commit no offense only if you have done something else. I'm not saying that the old woman was wrong in standing up. I was just saying that we're talking about an extreme situation. It may be a religious miracle. Someone who are already dead in such an extreme situation rises again on hearing the national anthem, or if we display images of some other situation which are not liked by the Chinese government, it may be regarded as ridiculed. Well, let me answer this question again. We have to look at whether there's an intention to insult the national anthem. If you look at the clip, of course, there's no insult. Well, what about the producer of the video clip? And if I'm a religious person and I use a more extreme depiction on whether the rise of a dead person, I'm talking about the producer and the publisher of the video clip. You know what I'm talking about. You haven't answered the question. The question is whether the producer or the publisher of the video clip has the intention to insult national anthem. Well, I was talking about the images showing the June 4th incident or the persecution of activist lawyers. With regard to the situation described by Mr. Wang, is it that we need to look at all the criminal elements in Clause 7? Well, the Permanent Secretary and I have answered this question already. We'll look at Clause 7, whether there's an intention to insult the national anthem, or is it really just about expression of political opinion? And also the burden of proof is on the prosecution, and the prosecution has to show the criminal elements and the relevant intention. Mr. Luk Chung Hong, I think there was already another question raised by another member referring to the old woman. Well, the old woman was a guerrilla fighter in the Japanese anti-Japanese war, and she could walk with crutches, and she always show her respect when the national anthem is played. So this is not a miracle or religious miracle. It seems that they are trying to take this to an unreasonable field. It has got nothing to do with religion, and we should not try to involve a religious miracle. Let me stress the point again. Please do not try to do some picking by involving that old woman. This is really the very unclever and unrelated. But this is a question of point of order. He said that these are dim-witted members. I hope he would withdraw this. I've never tried to say anything to insult the old woman in question. I said, of course, there's no problem with the act of the old woman. I was asking questions about the producer or the publisher. And this member has described other members as dim-witted. I hope you will withdraw his remarks. Do we have a ruling? Do we have other members who would like to speak on the same point of order? No? And I'll draw a line here. Mr. Chan Hang Pan? I want to ask you whether you are going to withdraw. Well, we withdraw the reference to dim-witted. I'm saying that they have got intelligence problem. This is easy to understand. The producer only makes something according to the actual situation. If that's the case, he may have a problem with understanding what's being depicted. You have tried to, I don't want to waste your time. I don't need to see the video. I don't want to take up any of your meeting time. I think I'm entitled to say or to respond to remarks made by other people. So I have a question for the Bureau. Let me make a ruling first on the point of order. Mr. Chan Hang Pan has withdrawn his remark with regard to the people who are dim-witted, but there's still a problem with the revised version that he has made. Why do I allow Mr. Chan Hang Pan to say something on this? Because we're talking about Clause 7. Mr. Andrew Wan has raised a question about relevance. Actually, Dr. Kwok Kake and Mr. Andrew Wan, you have both mentioned the video. And Mr. Chan Hang Pan has tried to offer an explanation because he knows what has happened. But he has also speculated on my motive, that I'm trying to demean other people. You know, I have said that. I don't think he's trying to speculate your motive. Well, are you trying to impute motive of Mr. Wan? I think you have already ruled on the point of order. I think I should move on to other points. I've been listening to the questions. Many of those questions are related to different scenarios, and they are getting to become repetitive. Chairman, you would remind members not to repeat scenarios or questions that have already been raised. It seems that the questions about the old woman have been repeated, and I hope, Chairman, you will do your best to remind members that they should not be repeating old questions. After you've drawn the line, and after Mr. Chan Hang Pan has withdrawn the remark saying that Mr. Andrew Wan is dim-witted, and he has not withdrawn that remark by substituting it with that the member has an intelligence problem. Well, I make a ruling. I will not make a ruling again. you make the ruling. You drew the line before before Chen Hanpan spoke. I'm referring to the Rule 44. Mr. Wen, please follow our rules of procedure. Well, you think you have a point. You're right, and I think I'm right. But I am the chairman. I make the rule. I make the ruling. Are you going to speak? You make a ruling. You're saying that dim-witted is okay. I think you are dim-witted. Well, Or I'll withdraw my remark of dim-witted. You being dim-witted. I would say that you have an intelligence problem. Mr. Chen Hanpan said that the pandemics are repeating the same points. Well, I'm one of those who have been here for the longest time. I've been listening to the questions. I don't think they are repetitive. Well, actually, the chairman would read out the points made by members in the form of a table, And although we speak at length, but we are not repeating our questions. Well, yes, maybe one or two questions have been repeated. Only 2 members have spoken on the issues related to the old woman. Well, you can ask the same question in 100 ways. I look at this substance, not the form. Well, you should tell Mr. Chen Hanpan this. We have substance. Well, otherwise the question will not be allowed. But of course, when it comes to the substance, whether there's something repetitive. Give us a table showing the form and substance. I've jotted down what the members have said. I have a good memory. Or perhaps you can tell us whether we have repeated the form of questions. Or you should clarify to Mr. Chen Hanpan that we are not actually repeating questions. Dr. Jiang Chongtai, if someone are singing the national anthem and some other people try to stop the singing of the national anthem, for example, in a religious activity, someone wants to play the national anthem, some of the participants think that the national anthem is inappropriate for the occasion and try to stop the playing of the national anthem. So I would like to know whether this is regarded as disrespectful or in any way commits the offense. I can only refer to the principles. When someone tries to stop the playing of the national anthem, is he intending to insult the national anthem? Well, you always refer back to the intention. Let's say a member is singing the national anthem, and I try to gag him by placing my hand on his mouth. Then you just an example. Don't be too serious. I don't understand. I don't get your question. If you always look at the intention to insult the national anthem, let's say a pro-establishment member is singing the national anthem and I place my hand over his mouth to stop him. Let's say, when you do this, do you have the intention to insult the national anthem? Well, I was not trying to insult the national flag. I was just trying to insult the pro-establishment members that they have ignored the national flag. But your case has already been judged in the court. So that's the problem. Miss Guadiamo, 73B. The Chinese term is a 貶損 or disrespectful, or 貶損 or disrespectful, or demean is very serious. Disrespectful is the English version. It should be demeaning or humiliating. There's a big mismatch here between the Chinese version and the English version. Oh, so the two versions that do not correspond. The translation is not in line with the other version. 貶損 means that reducing the dignity or injuring the dignity, and disrespectful is also the same thing. Well, I'm an English teacher. I know that different. Mr. Ted Hui, I have a question about the prosecution time limit. It's the end of 1 year after discovery by the commissioner, or the end of 2 years after the commissioning of the offense. I've checked other laws. It's usually the 6 months after discovery, or after 6 months after the offense is committed. Do you allow a longer prosecution limit in order to catch more people after the act? Usually, if there's no clear stipulation that the time limit is 6 months, now we have an explicit provision. It's the 1 year after the discovery of the commission of police, or the end of the period of 2 years after the commissioning of the offense, whichever is the earlier, because we think that sometimes such offenses will be committed by a large number of people, and collection of evidence takes time. That's why we have provided these time limits. But do you agree that this is the longest prosecution time limit among similar laws? Under the MPF ordinance, it's 3 years. In the copyright ordinance, it's the time limit is 3 years. But whichever is the longer of the two, rather than the earlier. Mr. Chan Chi-chen, if you do not allow other people to play the national anthem, if I press the button to stop the playing of the national anthem, would that be an offense? I think you would say this is really about the intention, but it's not a question of the subjective intention. Let's say if in a religious event, I think that the national anthem should not be played, and I want to press the button to stop the playing of the national anthem. Would this be regarded as affecting the dignity of the national anthem? I think the answer can be found in the question. But the court has to be satisfied with the evidence presented by the prosecution that there's an intention. It's not a question of what the court thinks subjectively. Mr. Wu Chi-wai, question about 7(7). And before the end of the period of 2 years, and someone reports the case to the police, then is it that the police has another year to investigate before initiating the prosecution? As I have explained, but the discovery means that the Commissioner of Police has got hold of information. It doesn't mean that all the elements of the offense has already been proved. But there's the need to collect evidence. So would the Commissioner be given another year after the discovery? It's not a question about the discovery, not about the collection of evidence.
或者係
It's end of 1 year after the offence is discovered or 2 years after the date on which the offence is committed, and the earlier should apply. If 1.5 years after the offence was committed and only then the Commissioner comes to be aware of this, then he would take 6 months to investigate. So it doesn't mean that the whole process is completed after the case is taken to court. So it's a time when you issue the summons, right? It will start from there. Claudia Mo. Somebody told me that on the cell phone there is a video clip showing somebody was trying to, make a prank and alter the lyrics of the national anthem. Somebody recorded that at the scene, and that video clip has been widely circulated on the internet among friends, and it's circulated among friends but not circulated on the internet. If somebody discovered this on a person's cell phone, would that be a problem, and is there a time limit? So in the cell phone of some person, there is a video clip showing some people, making a ridicule of the lyrics of the national anthem, and it's not deleted. Is that an offence? If the owner of the cell phone, himself or herself, has not committed an act to insult the national anthem, or if he doesn't have the intent, then he's not guilty. Fernando Joe. Thank you. I'd like to go back to that video clip. I understand I only have 1 minute. I didn't intend to raise this, but since Chen Pan has referred to it, I think he has actually, he's really wrong. He's really wrong. I think we now have, an API showing that an old lady on the wheelchair will still need to stand up, try her best to stand up when the anthem is being played. So what message is being sent here? The message is that whatever your physical state, you have to stand solemnly when the anthem is being played. For people who are disabled, then they will really be worried. That is the formal requirement or the etiquette to observe. If somebody really try to stand, then he or she may fall. I don't really want to talk about this today. We only talk about the penalties, but I would like to suggest to you that you would delete that video API so that the wrong message will not be sent to the public. Thank you. Mr. Lockheen. I'd just like to make 2 points. I'd like to quote the case of Gong Xiu. I'm worried that if somebody has not committed an act, but he simply said something which has the intention to insult the national anthem, would that be tantamount to inciting people to insult the national anthem? I was just quoting the Cantonese version of the March of the Volunteers. If somebody were to perform that, would that be an insult of the national anthem? Because if that's the case, it would be a threat to freedom of speech on the internet. And secondly, I'm worried about the term altered, because when the Chinese and English translation do not match, then there will be difficulties when it comes to the onus of proof. Mr. Gary Fang, you're 7th round. I'll go back to a question I asked earlier. I'm not going to repeat what have already been raised by other colleagues. That is, the phrase in any way involving, altering, undermining the dignity and so on. So what about the booing of the national anthem? If it is not, stipulated in the bill, is it that the government has decided that you cannot include it into the bill and therefore you are replacing it in another way? Is it that in the bill, in the law, you cannot specifically define what does it mean by booing the national anthem, and that's why you've expressed it as in any way? I think the present draft, I think in the national anthem law, you have terms. It includes the altering of the or distorting the or insulting the national anthem in any way, and all these three scenarios are already reflected in the bill. If booing is also included, you should provide for that in the bill. You will say that it's not allowed, but you've not clearly, explained that in the bill. If you did that, the public would know. Why are you saying instead that you're replacing that by in any other way? Can you exhaust all possible forms of insult regarding the different possible scenarios? I think what is clear in the bill is that we've listed all the elements. That is, you publicly and intentionally insult the national anthem. Mr. Fan cited some specific examples. Mr. Ray Chan. Booing the national anthem law or singing or performing the anthem in a distorted way and so on, I understand. But I'd like to go to Section 8. Both the score and the lyrics are governed by Section 7. Let's say if I tear up the lyrics or the score of the national anthem, would that be an act that is insulting the national anthem? Give an extreme example. I would simply actually, cut up all the lyrics of the national anthem and ask Dr. Chang to rearrange them, and he cannot do that. Would that mean that it is a distortion or altering of the national anthem? Secondly, in Section 8, you're referring to text but not symbols. I asked earlier why you don't provide for the phonetic symbols for the lyrics of the national anthem. If we're talking about symbols, would the symbols be regarded as the score or the lyrics of the national anthem? Now, to answer the second question first, the lyrics of the national anthem is contained in the schedule of the bill. Only the lyrics shown in the lyrics would be considered to be the national anthem. As for the scenarios suggested by Mr. Chan, I think we still need to look at the way the person commits the act and what his intention is. Whether or not there is an insult, if we tear up the lyrics of the national anthem, if objectively we can prove that he has that intent, then he would be, of course, guilty. Claudia Mo. I understand you cannot specifically define which are the behavior that would be an insult to the national anthem. But at least in the law, you should actually include some general behavior. If you simply say insulting the national anthem in any way, I would be scared, because it's up to you to define what would be an insult. I think we all understand that this actually, this is because a large number of the football fans were booing the national anthem in a football match. We all know that's the background. Why don't you also provide for that in the bill? For example, X would include the booing of the national anthem. Have you not considered that? I see Mr. Gary Fan just asked the same question earlier, but he didn't ask the question the way that I did it. Now, I don't think you can interpret my question like that. I think you were asking the same question Gary Fan asked, except that you phrased it in a different manner. I said, I will allow this question. I asked him to at least give me an example. I'll allow this for the last time. I think our purpose is to reflect the legislative intent of the national anthem law. Well, you have football fans booing the national fan. The question is whether this example we don't want to avoid defining that in Section 7 regarding the term insult, regarding undermining the dignity of the national anthem. I don't know whether or not you have a definition for dignity. I think when we had the policy discussion, this point had been raised. When we had the policy discussion, we already did cover that in our enactments, that we have used the concept of dignity, but there is no definition. The court will actually interpret it based on the literal interpretation of the literal meaning. I think in other legislation we may be talking about individuals. Is there any legislation which has to do with the dignity of the dignity of some of the countries? The national flag and the national emblem ordinance already use the term dignity. In other legislation, the dignity may not just concern individuals. Gary Fenn, I'd like to, ring the bell.
我希望我認為
I think the scrutiny of this part is nearing the end. So those members who have not yet pressed the buttons, please do that as soon as possible. Claudia Mo. Thank you. 7(8)B. I'd like to ask a question regarding the Chinese translation. You talk about publishing to distribute, disseminate, or make available to the public. I don't think there's any problem with the English version, but the Chinese translation, 全部, I think is rather odd. We would say 發布, you know, and I have some questions regarding the version of the word 報. I think there in Chinese we have 發布, but what about 全部? Disseminate, you translate that as 傳播. The dictionary will translate that as 傳播. Are you saying that you are borrowing the Chinese, you know, the words in both Chinese and English from the mainland law? I think for the Chinese version, we'll try our best to make reference of the national version. I think publish has the meaning of 傳播 and 散布, and it is comparable to spread, promulgate, or disseminate. I don't think he's answered the question. In Chinese, where do you find the term 傳播? Yes. Why didn't you let him answer the question? I've seen how this term being used in the dictionary. Ray Chan. I have one suggestion. Insult and also libel are similar. Take permanent libel, maximum penalty is 2 years imprisonment. It's less than the penalty for insulting the national anthem. High Court Ordinance 33A, there you have it provide for a trial, you know, by jury. The enforcement of the national anthem law is that the judge alone can make the decision. Would you consider amending Section 33A of the High Court Ordinance so that this bill would be, any offense in relation to this bill will be put to trial by jury?
陳志全議員，你
So that would change the judicial system, Mr. Ray Chan. Well, this is just my view. Yes, I've heard your view. But we are taking reference from the National Flag and National Emblem Ordinance. I would like to ask the Secretary, when you answered Mr. Charles Mock's question, that is about spreading online, no matter whether it's the IP address or the registered person, when they share such information, well, they may share it across different territories. You say that in the future, before you initiate prosecution, you will seek legal advice. So why will you be seeking legal advice? Will it mean that you cannot collect enough evidence, or because the act itself is across different territories and you do not have enough justification to prosecute? What kind of legal advice are you talking about? Mr. Joe Chan? There are two parts. First, well, after collecting evidence, if possible and if needed, we will seek the advice of the DOJ to see whether the evidence is sufficient. And also, through mutual legal assistance, we can ask overseas authorities to help us. And we would also seek legal advice of the DOJ. That is, you are asking overseas authorities provide information to you, right? And that will be evidence. Yes. For those who haven't pressed the buttons yet, please try to press the buttons as soon as possible. And I'll draw a line at around 6:20. Claudia Mo. For Clause 7, The title is Offense of Insulting Behavior. Just now, you said that for the Chinese version, you copy it from the national anthem law of the PRC. As for the English version, we do it ourselves. So when you decide to use the word insulting in the English version, have you considered the word humiliating? Would that be a better word? For myself, I think the word demeaning may be even more serious. It says in the dictionary that it causes a severe loss of the dignity of and respect for someone or something. So why don't you use the word demeaning, but you use the word insulting? Lord Draftsman? For the section heading, well, for the mainland law, they do not have section heading. We did it ourselves. But for the word insulting, we think that it is more appropriate to express the meaning. When we look at the word insulting, we know immediately what it means. You think it's more appropriate, so you do not consider other synonyms. Mr. Ray Chen? Earlier on, I was talking about turning off other countries' national anthem. Now for Schedule 3, it's occasions on which national anthem must be played and sung. Now, so if the occasions are other than these occasions, people will still play the national anthem. For example, in a park, some middle-aged ladies are doing exercise and they sing national anthem and I find it a nuisance, so I boo them. So would it becomes a booing the national anthem? And of course, the secretary would talks about the intent again. Just now, this question was asked. I'll answer Mr. Chen's question. For Schedule 3 or for any occasions on which the national anthem is played, well, we must look at whether there's an intent to insult the national anthem. Mr. Alvin Yang, I want to ask about collecting evidence. In the future, if it is suspected that people have committed an offense under Clause 7 online, must the police get a warrant to seize the personal items of the suspect, including the computers? Mr. Zhou Chen, if it involves the seizure of the suspect's personal items for evidence, well, we must apply for a warrant from the court. So the police can tell the public very clearly and assure the public that in the future, if anyone is suspected to have committed an offense under Section 7, the police must get a warrant from the court before seizing that person's personal items. Mr. Chen, according to the law and according to Cap 232, the police are authorized to seize certain items without a warrant. However, under normal circumstances, if we need to do such a seizure, we normally would apply for a warrant from the court. Mr. Gary Fan, I would like to ask about a parody. If a netizen parody a national anthem video and another netizen B leaves his comments and he maybe says it's rubbish, or he may be criticizing the person that created this video is a rubbish, but he may be suspected to have insulted the national anthem, saying that the national anthem is rubbish. So would he have committed an offense of insulting the national anthem? We have to go back to Clause 7. Well, the prosecution would have to collect evidence, and without reasonable doubt, they would initiate a prosecution, and the court has to be satisfied with that. Claudia Mo, 7(3)(b). About this distort. Well, to me, why Cook's English should be twisted, but here you use the word distorted. This is not copied from the PLC. So what is the difference between twisted and distorted? Why have you chosen the word distorted? Lord Draftsman? Chairman, for English we use the word distorted because in the dictionary it's the same as make crooked, and that is a tantamount to the meaning of why cook. So we use distorted as why cook. How about contorted? How about contorted? Or misrepresented? I think in terms of law, these are more meaningful words because distorted is a very negative word. I can provide information. Well, for in Article 15, they have this word. They use the word. They have an English version, and they use the word distorted. For those who have not pressed their buttons, please press the buttons now because I'm going to draw a line here. Okay, all done. I'll draw a line here. Next, Mr. Lo Wai Kok. Chairman, as you have drawn the line, maybe I'll spend some time on this. I don't want the public to think that I'm dragging my feet, but I've heard members talk about the Chinese word 全部. It's not like what some members say. This is a term from the mainland. Actually, it's an Asian term. It already appeared in the Tang Dynasty in a book called 新唐書, and it was written by Ouyang Shao and other academics. So it was about the history of the Tang Dynasty, and they have already used the word 全部 in there. Mr. Charles Mock, I would like to confirm this. That is about the hyperlink. Well, the hyperlink consists of only a series of letters or alphabets. When we discussed the copyright bill, we were quite sure that sharing a hyperlink has no problem. But this time around, you have to tell us clearly. That is, even by after sharing a hyperlink, you still have to look at the intent of the person. So the way of handling this here is different. So if you have the intent, then even if you share a hyperlink, you would still have committed an offense. Yes, when you share it, no matter whether you are sharing the whole video or you are sharing a hyperlink, you would have committed an offense. But the hyperlink doesn't show what the intent is. You have to look at that person's intent, right? Yes. Fernando Zhang. Well, for insulting the national anthem, now you have set out a list of behaviors under Clause 7, and this would become criminal offenses. Well, this may restrict people's freedom of speech and expression. For the case of Ngong Xiu, there are a lot of discussions about the legal aspects. Some people think that we should try our best not to impose so many restrictions as long as there is not a clear and present danger, and as long as the speech does not incite violence. We should be very open. even though the national anthem is a symbol and sign of a country. But some other people think that even though we have the basic laws, still we can impose certain restrictions on the freedom of speech. So now you are adapting the national anthem law in Hong Kong. So can there be a reasonable defense, or can you make the behaviors clearer so that the restrictions can be clearer and people won't be caught inadvertently? There are 2 points to Mr. Zhang's questions. First, now we are imposing reasonable restrictions. We are restricting the ways of expression. You can express your views, but you cannot do it by insulting the national anthem. And also the relevant elements are set out here. That is, if you insult the national anthem, you have to do it publicly and intentionally. And also the burden of proof lies with the prosecution, and it should be proved beyond reasonable doubt. So there are a lot of safeguards already, and I think we have been very careful. Mr. Ray Chan, I would like to ask about the police powers. Of course, you have to collect evidence to prove if that's an intent or not. So can you search the computer history of that person? Do you have to go through certain legal procedures to do that, or can you even intercept his communications? Mr. Zhou Chen? Well, for any person who may have breached Hong Kong laws, we will try our best to carry out investigation and collect evidence. Mr. Chen asked if we would check that person's computer history. Yes, if there is a need, we will apply for a warrant from the court. As for getting information from the service providers, we would invoke the Personal Data Privacy Ordinance. When the Secretary answered Tanya Chan's written questions, you said that the National Anthem Bill is to safeguard public order. And this is not just about public security. And you say that this is also to ensure human rights and to make sure that people enjoy well-being. So for all these insulting behaviors, you think there is a need to penalize these people because they insult the national anthem. But how can this satisfy the people's needs? Actually, in the case of Ngong Siu, there has been some very clear explanations. The national flag is the symbol of the nation, and this is the collective interest of society to ensure to preserve the dignity of the national flag. Now we are talking about publicly and intentionally insult the national anthem. Well, publicly, we all know about it. And if it's an insult or not is common sense. But for intentionally, it's about intent. Well, you say that the prosecution would have to adduce evidence. So how do you do that? Because you are talking about the person's state of mind. It may seem insulting, but maybe he didn't do it on purpose. He may insist that he didn't do it on purpose. I think this is still very ambiguous. So it has become a draconian law. You have to look at this. Well, for the element of intentionally, In other criminal offences, we would also find that the prosecution would have to prove that the suspect did this intentionally, beyond reasonable doubt. But how do you prove intent? Can you cite an example so that we can rest assured? So when a person states his intent before acting on his behavior, then that's very clear. Yes, if he says so, of course, but if you say he does it and he intentionally and he denies it, what would happen? Okay, we have wrap up the discussions of Clause 8, and next time we will start the scrutiny of Clause 9, and I will invite officials from the Education Bureau to attend the meeting.